First of all, thank you all for coming on this absolutely gorgeous last day of Indian summer in the middle of the fall before the snows rejoin us in Cleveland. And I know some of you are distracted by the Browns playing this evening, and many of us are still trying to catch up on sleep from being up all night on election eve. But today we have a really exciting speaker for you, and so you're going to be very happy that you came. Let me begin by introducing myself for any of those of you who haven't met me before. I'm Michael Scharf, Professor of Law and Director of the Frederick K. Cox International Law Center, which is the international center here at the law school that works closely with other international programs, including the Canada-U.S. Law Center and our Institute for Global Security, Law, and Policy. This lecture was endowed in 2001 by Bruce Klatsky, who's both a trustee of this university and also a trustee of Human Rights Watch. And he gave us a nice large sum of money that allows us to bring people from the four corners of the world to give us cutting-edge lectures on the most important human rights issues facing our country and the world today. And the list of the people who've given our Klatsky lectures in the last couple of years, I think, will probably also be the list of people you see the new president appointing to high-level positions in his government. For example, Harold Koh gave the first lecture, and he is on the short list of those thought to be the next appointee to the U.S. Supreme Court. Harold Koh was the Assistant Secretary of State for Human Rights in the Clinton administration. Ken Roth, the Executive Director of Human Rights Watch. Eli Rosenbaum, who runs the Office of Special Investigations at the Department of Justice. David Crane, the former prosecutor of the Special Court for Sierra Leone. Mike Reisman, the famous and influential law professor from Yale. And Samantha Power, who was most famous, I guess, for what she said during the elections in the heat of battle against Hillary Clinton. But she is someone who got the Pulitzer Prize for her book on genocide and is very likely, I think, to play an important position in the next administration. And all of these folks have come in the last few years to talk to us, and now we can top them all because we have the wonderful Geoffrey Robertson. I've known Jeff for many years. We served together on the elite team of people that were working with the judges of the Iraqi High Tribunal to try to prepare them for the Saddam Hussein trial. Geoffrey has had a very long history and career of litigating human rights cases and also constitutional cases all over the world for international tribunals as well as constitutional courts. He's Queen's Counsel, which most of you who know anything about the United Kingdom know he's part of that elite cadre of super lawyers in the United Kingdom. He was the president and appeals judge of the Special Court for Sierra Leone, which is currently prosecuting Charles Taylor in The Hague. And he has written many important books, but two of them which are widely read and critically acclaimed. One is called The Tyrannicide Brief, which is a story of the trial of Charles I. And one of the interesting moments of the Saddam trial was when he was actually quoting from that book about what Charles I said when he was being prosecuted, and he said, "By what authority are you prosecuting me?" And the other book is his famous book on crimes against humanity, which is literally the Bible that everybody in this area, including all the judges of the international tribunals, have on their desk. So without further ado, it is a great pleasure to present to you Geoffrey Robertson.
Well, thank you, Michael, for that overkind introduction. I was speaking in Glasgow the other day where the chairman, a broad Scotch accent, introduced me as that distinguished liar. Maybe that is more appropriate for an advocate. But it is a signal honor to be here, to be invited to give the Klatsky lecture, and a real privilege to be transported to America in such an auspicious week, such an auspicious time, when this great nation has elected as its president a man who is the living embodiment, if you like, of the potential of human rights, a beneficiary of Brown and Board of Education, of the struggle for equality, against discrimination, and for civil liberty. the triumph of Barack Obama, hailed most graciously of all by his opponent as historic, vindication of American democracy and faith of its founders. Thomas Friedman has called it the end of the Civil War. Well, it's hailed abroad, or received abroad, with shock and with awe. At a stroke, this nation seems poised to recapture the moral leadership that was lost over torture at Guantanamo, Abu Ghraib, Iraq, extraordinary rendition and defiance of the United Nations. Anti-Americanism simply isn't an option in the world at the moment. Your enemies, they're enemies of humankind because they want to kill Americans and anyone else who gets in the way, have really lost the sympathy of the community, the sympathy that warms the pool in which terrorists breed and multiply. And there seems to me to be now a moment, it may last months, it may last years, when America can reclaim its position as exemplar of the possibilities of freedom, when it can boost the struggle for global justice by re-engaging with it and re-energizing it. In this lecture, I will try to suggest some of the things that the Obama administration could do and could undo to lead the struggle against tyrants and terrorists in the world. I want to as well look at how the ideal, if you like, of universal human rights, that human rights are not merely a national thing for individual countries to select their own, but some of them, elemental more than fundamental, are universal. This lecture has been endowed by Bruce Klatsky, who's a trustee of Human Rights Watch, as part of his generous assistance to its work. Human Rights Watch is an organization that more than any other throws down the gauntlet to politicians and power brokers by telling not only of atrocities in faraway countries, of which we know little, but how they can be ameliorated and avoided in the future. It analyzes with expertise and then advocates with restrained passion and a sense of what is politically possible. I've worked with Human Rights Watch presenting the case in the English courts against General Pinochet, supportive of his arrest and extradition. I worked with them. They gave us a lot of advice on setting up the War Crimes Court in Sierra Leone, and I can attest to its insight and street wisdom. It lacks the funds that mass membership organizations can obtain, and so it's to Bruce Klatsky and like-minded supporters deserve our thanks of all who cherish its ideals of turning what is at home has been a struggle for civil liberties, into the idea of human rights available to everyone on the planet. Well, that ideal, of course, was presented by Eleanor Roosevelt almost 60 years ago exactly, on the 10th of December 1948, when she presented to the General Assembly the Universal Declaration of Human Rights, which she's described as a Magna Carta for mankind. That was intended, of course, to deliver on her husband's famous promise after America entered the war in 1941 of 4 freedoms: freedom of speech and religion, freedom from want and from fear. The following year, President Roosevelt ensured that the Atlantic Charter contained a commitment to fight the war, to secure human rights not only in America and not only in Allied countries, but throughout the world. Mrs. Roosevelt's committee received daily transcripts from the trial at Nuremberg, and the declaration inspired by a determination that those horrors should never happen again. Of course, they did constantly, and today the future of human rights is still a matter of delivering on those promises 60 years ago. Because there was a remarkable point in the UN deliberations in 1948 when, led by Britain and Australia, the committee considered making the Universal Declaration legally binding as a matter of international law with its own court and enforcement. And the American Bar Association presented a most powerful argument in favor, which for a time received American support, and the US was in support. Of course, it was vetoed by the Soviet Union and its puppets. But there we have, 60 years ago, the promise that human rights would be enforced, and we have come some distance to enforcing them universally against torture, against genocide, and against slavery. International crimes now that attract international consequences. The question today is how to make those consequences more certain, more predictable, and how to offer some international protection to other rights, rights like freedom of speech and the right to free and fair elections that are so constantly abused. Before suggesting a way forward, I want to say something about the past and America's place in it, in the conception of certain rights, elemental more than fundamental, that are truly universal. That arose first from the battle against royal absolutism that we fought, not of course, Magna Carta, which was in its time, 1215, a rather squalid deal between the king and some thuggish barons, but how Magna Carta was reinvented in 1628 as the Declaration of Right, reinvented by the remarkable Puritan MPs who conceived of Parliament sharing power with the king. And the king responded to the Declaration of Right by abolishing Parliament. For the next 11 years there was no Parliament, and he persecuted those who were of that Puritan Congregationalist persuasion, tortured the preachers, oppressed the people, closed the congregations. That was when John Winthrop led in the 1630s 30,000 people from Britain to Massachusetts in search of the city of the hill, on the hill. And back they came. Back they came in the 1640s to fight with Parliament. It's not widely known that most of the first graduating class of Harvard College turned out in Cromwell's army as generals. Indeed, George Downing, the second person to graduate from Harvard, became Cromwell's Kissinger in the days of the Republic, has Downing Street named after him, where British government derives. So in that marvellous time when, in the 1640s, when Parliament fought for the right of no taxation without representation, actually, that was what it first fought for, but it abolished the King's Court of Star Chamber. And that had these consequences. Firstly, it was the end of torture. Torture, abhorred by the common law, abolished in 1641. No longer would people have their ears cut off and branded with hot irons, SL, for seditious libeller when they attacked the king. It was a matter of great pride, because for centuries the French kept, and the Spanish and the Europeans kept torturing. Torture was something that was done by the French, as the British jurors said. It was formally done, rather like Alan Dershowitz would like it done, by order of a judge, and you then were put on the rack to confess. Well, that was the end of torture. It was also, more importantly, I think, well, just as importantly, the beginning of the independence of the judiciary, because previously, in the ship money case and the Stuart kings, whenever a judge decided against them, they sacked him, because judges existed at the king's pleasure. And the abolition of Star Chamber was accompanied by a rule that judges should hold office until misconduct. So it also abolished censorship. The Star Chamber was the censor, and for a marvellous few years we had utter freedom of speech, and an incontinence of pamphlets and books about the kind of democracy that should develop. And, of course, it was ironic because the king was believed by the population to be the vicar of God on earth. He was believed to be the God's choice. And although he lost the First Civil War in 1646, he was still the enemy commander and was still king. And this was a great paradox. And as someone said to Cromwell, if we beat him 99 times, he's still king. He beats us once and our heads are off. So the Second Civil War he plotted from his prison in the Isle of Wight, and it was a very vicious civil war. 1 in 10 Englishmen lost their lives, and it was then that the Parliament, a purged Parliament, no doubt, but nonetheless the Parliament in 1648, in setting up the court to try Charles I, did so with these words, that the purpose of this court was to the end that no chief officer whatsoever may hereafter presume to contrive the enslaving or destroying of the nation and expect impunity for so doing. And this word impunity enters the English language as the freedom that tyrants should never have to live happily ever after. And the king was charged with the crime of tyranny, a crime committed on the evidence that was called by his torture, supervising the torture of prisoners of war, committing war crimes, starting a war that had killed so many of his own people. The trial of the king, in effect, confirmed the great gains of the initial period of the Civil War. They made the mistake, of course, of executing him, a great mistake that we'll return to, and is still a matter that concerns us, what punishment is appropriate for those convicted of mass murdering their own people. But and that made him a holy martyr. And after Cromwell's death, of course, his son returned. But the monarchy could not recapture its absolute power, habeas corpus, the independence of the judiciary, comparative religious toleration, all the gains that had been achieved in the 1640s could not be wiped out. Nonetheless, they had an awful lot of Republicans, dangerous Republicans, to deal with. And the judges of the king were sentenced to death, a quite barbaric death of hanging, drawing, and quartering. Not only the judges, but the ideologues. Hugh Peters, the founder of Harvard University, Henry Vane, former governor of Massachusetts, were tried at the Old Bailey by a prosecutor who alleged that they were terrorists who'd been set up and persuaded by fundamentalist Puritan preachers in Massachusetts to come back and persuade Cromwell to cut off the king's head. It was a terrorist trial of its time. But the courage of those men, as their sexual organs were cut off, they were disemboweled, and they died in the stench of their own excrement, and they were then cut in fours, quartered, and their limbs were stuck on the gates of London. Their courage in refusing to renounce their principles of republican government caused a great swing in the crowd, a mood swing. The crowds who had welcomed the king back were suddenly so awed by the courage of these men that they decided they were swinging against the king, and the king still had hundreds of dangerous Republicans in prison. They couldn't be brought to trial, but they couldn't be left in prison because habeas corpus was still there, the great writ that would deliver them from jail. So the king's very clever advisor, Lord Clarendon, said, "I know, a great idea, let's put them on offshore islands where habeas corpus doesn't run." And they did. They put them all on Jersey and on islands off Plymouth, and so it was regarded as a very devious idea even then. And when Parliament got its act together in 1679, it passed the Habeas Corpus Act to apply to offshore islands. And, of course, as Justice Stevens, I think, pointed out in the Supreme Court in Hampden versus Rumsfeld, that act was still in force because, after all, America was part of England at the time. So in 1688 we had the Bill of Rights when, with the promise of no excessive bail and no cruel or unusual punishment and the right of free speech in Parliament. And these rights, this great struggle in the English Civil War, inspired the founding fathers of this nation in 1776, certainly inspired Tom Paine with the writer of Common Sense and the Rights of Man, who it's often said at the beginning of the year of 1776 everyone was in favour of doing a deal with King George until they read Common Sense. And it was an inspiration. When, of course, when Jefferson came to draft the Declaration of Independence, the first draft, when we hold these truths to be sacred and inviolable. Smacks of the pulpit, Mr. Jefferson, said Ben Franklin. These truths are, well, they're self-evident, aren't they? And that was how the Declaration started, or at least according to the mini-series on John Adams, which I assume is correct. But the rights of man that were declared by the French Revolution and the American Declaration were confined to the French Republic and the American Republic. The right to bear arms, for example, has not caught on, I'm glad to say. But they were, more importantly, they were based on natural law. They were based on God-given inherent rights, natural rights. And, of course, in the years to come, in the following century, the whole idea of natural rights was destroyed from the liberal side by Jeremy Bentham, who depicted them as nonsense on stilts, by Karl Marx in his essay on the Jewish question in 1848, who tore them to pieces as bourgeois rights, the rights of egotistical man. And so by the end of the century, indeed by the beginning of the First World War, there is no idea, no concept of human rights. Theodore Roosevelt, I think, to justify the invasion of Cuba, talked about the right to act when the indignant pity of the civilized world is, but he was, of course, defending that invasion. And the Armenians were slaughtered. The New York Times had very full accounts of the Armenian genocide in 1916. Nothing was done after the war. Some of the Young Turk leaders were put on trial for a short time in Malta, and those trials petered out. In fact, wasn't it Hitler on the Polish border urging his generals to show no mercy, who said, after all, who now remembers the Armenians? The Versailles, the end of the First World War, Lloyd George came to Versailles determined to hang the Kaiser. Wilson stopped it. Woodrow Wilson and Lansing thought that sovereign immunity, the claim of Charles I, that since he was the sovereign he was immune, his lawyers had came up with a great defense based on Magna Carta. They said Magna Carta requires trial by peers. You're the king, you have no peers, so they can't put you on trial. And this idea was supported by America. So the Kaiser went off unhung. He lived unhung in Switzerland or in Holland, I think, until 1941. And throughout, it's quite fascinating that throughout the 20s, throughout the 30s, there is no concept of universal human rights. No one talks about human rights in the European intellectuals or in the debates in the League of Nations. And it is only in 1939, just before the war, that an extraordinary group of English intellectuals, writers, socialists, led by H.G. Wells, who and by J.B. Priestley, A.A. Milne would motor up from Pooh Corner to add his tuppence to the draft, produced a declaration of the rights of humankind and the idea that they should be enforceable universal human rights, based not on natural rights, but on human dignity. It began, since a man comes into this world through no fault of his own, he is entitled in justice. So it was justice married to the idea of human dignity. It was an extraordinary, it was a bestseller. It came out in a little Penguin special. It was translated into 30 languages. It sold hundreds of thousands of copies. H.G. Wells on the Rights of Man. The Foreign Office actually translated it into German and dropped it on the Nazi tanks as they were crossing France. Of course, they didn't stop to read it. But the person who did read it, and here one of these extraordinary synchronicities of history, Wells was a great friend of Franklin Roosevelt, who admired his work. And Roosevelt read it and was inspired to make his Four Freedoms speech, inspired to draft in the Atlantic Charter that complete victory is essential to preserve human rights and justice in their own lands and allied lands, as well as in other lands. So human rights becomes a war aim based on human dignity. Then, of course, we come to enforceable human rights, what to do about the Nazis. Churchill, who was a great admirer of Cromwell, thought that the trial of Charles I had been a great mistake. Shouldn't put dictators on trial. He was afraid that Hitler would use the dock as a soapbox and preach Nazism. So he came up with the idea that they should list the 75 top Nazis who'd be given 6 hours on arrest to say their prayers and then would be executed. And that was, Stalin was like the idea. He said, well, as long as there's 75,000 Nazis on the list, we'll go for it. But this was not, of course, it didn't sit well with Truman and with his advisor Jackson. And there is a marvelous statement in which they put their position. To free the Nazi leaders without trial would mock the dead and make cynics of the living. On the other hand, we could execute them without a hearing. But undiscriminating executions or punishments without definite findings of guilt fairly arrived at would violate pledges repeatedly given and would not sit easily on the American conscience or be remembered by our children with pride. The only other course is to determine the innocence or guilt of the accused after a hearing as dispassionate as the times and horrors we deal with will permit, and upon a record that will leave our reasons and motives clear. That great statement, drafted, I suspect, by Jackson and uttered by Truman, was the American position. And there was a complete deadlock between the British and Americans. It was broken, of course, by Joe Stalin, who loved show trials as long as everyone got shot in the end. And so he voted for Nuremberg, and the Nuremberg transcripts informed Eleanor Roosevelt's committee. And in 1948 and the early months of 1949, we get this great human rights triptych, the Universal Declaration, the Genocide Convention requiring states to go to war to stop genocide, and setting up, if necessary, an international court to punish it, and then the Geneva Conventions relying or requiring humane treatment for prisoners of war. Well, of course, they went into the deep freeze of the Cold War. We had in the next 50 years lots of good conventions against racism, against torture, against the maltreatment of children, and so on. Someone said, surveying the killing fields of Rwanda, the road to hell is paved with good conventions. There was just no enforcement mechanisms attached. Human rights became a kind of ideas to be used in rhetoric to hurl against each other, the Gulag on one side, the Jim Crow laws on the other. Although I did spend a little time to prepare for I was in Boston on the election night, and to prepare for it I went to the JFK Library and watched his 1960 inaugural, and it's all about human rights. That's all he talks about. It's extraordinary, marvelous but it was, of course, asserting in rhetoric the claim of human rights against the Gulag. But at the end, even as late as 92, I remember in Sarajevo hearing the black joke about what do you do with a man who kills another man? You send him to prison for life. What you do to a man who kills 20 other people? Well, you send them to a mental asylum until they're cured. What do you do to a man who kills 200,000 people? You send him to a luxury hotel in Geneva for peace negotiations. Well, that was told of Milosevic, and of course it got blacker as the 90s went further. And it was only at the very end of the 20th century that we came up, initially with the ICTY in The Hague and the ICTR, punishing the authors of the genocide and mass murder in Rwanda and in the Balkans, set up really as a fig leaf to cover the UN's inaction. But slowly, with Madeleine Albright and Robin Cook and changes in political leadership, actually arresting generals, concentration camp commanders, and finally, of course, Slobodan Milosevic. We had the Pinochet case, where General Pinochet came to London to have his back examined and to take tea with Mrs. Thatcher, though it was actually whiskey. And there he was arrested. And, the extraordinary eruption from around the world. We had President Bush, we had the Pope and the Pope in waiting, we had Henry Kissinger, all saying release General Pinochet, the fragile democracy in Chile is at risk. My favorite protest was from Fidel Castro, who said that it was an outrageous insult to Latin American dignity that General Pinochet should be put under arrest. And, of course, we had the Rome Treaty for the ICC, 5 weeks in which we saw the first U.S. wobble because David Sheffer, running the U.S. delegation, was wanted, I think, himself, and I think many of the delegation wanted America to support the treaty, but it was a time when Monica Lewinsky's blue dress had been sent for DNA analysis. The Pentagon was opposed to the treaty, and ultimately America didn't sign it. The last act of President Clinton was to sign it. The first act, or one of the first acts of the Bush administration, was to unsign it and to embark on a vigorous and rather vicious attack on the International Criminal Court, blackmailing a lot of countries by threatening to withdraw aid and to withdraw military support unless they refused to have anything to do with it. Jesse Helms put through the American Servicemen's Protection Act, which we loosely refer to as the Bomb the Hague Bill, which enabled the President to release the Marines to free anyone who was taken before the International Criminal Court, any American who was taken before the International Criminal Court. Charles Taylor, who claims to be an American, is under trial there at the moment, and there has been no attempt to free him. Then, of course, came 9/11 and the argument that the Geneva Convention was obsolete, so it didn't apply to Guantanamo. I mean, in some ways, the Geneva Convention for prisoners of war is a creature of its time. I dealt with it recently when I was president of the Sierra Leone court in adapting it to our prisoners. And, of course, when you read it, you realize that one of the most important rights that a prisoner can have was the right to smoke. It wasn't a right that I put on. But it does have echoes, yes, of the officers' mess at Colditz, and it is dated, but in essential requiring a basic humane treatment, it is as vital as ever. And the rule against torture, redefined to mean pain, the equivalent of the loss of a bodily organ, and so forth, led to a loss of moral leadership by America. In many ways, I think, it's unfair to the Bush administration because they have done quite a lot. Their massive work on HIV/AIDS, they've supported ad hoc courts, my own in Sierra Leone most particularly, and I've worked with John Bolton in achieving a reform of the internal justice system at the UN, which was very important. But of course, the bark, the seemingly cavalier attack, this idea that international law was fine for other countries but not for America, did lead to these problems. Well, now at a time when America is gearing up for its new administration, when the world has very high expectations of this country resuming its leadership in the free world, at a time when terrorism, however, is still a threat, when old conflicts linger, see the Congo, and where recession will limit expenditure, what might the Obama administration do? Well, first and foremost, we would hope that it re-engages with the International Criminal Court. 107 nations have now ratified the Rome Treaty. There will be a conference. The review conference is in Kampala in 2010, and this would be an opportunity for America to seek at least an associate membership, which would enable it maybe to block in the Security Council any attempt to investigate its politicians. That would be easily negotiated. But at a time when the ICC has done absolutely nothing to against the interests of America. Indeed, the latest investigation its prosecutor is undertaking is into Chavez and his connections with the FARC kidnappers in Colombia. It has no anti-American agenda. It has 2 Congolese warlords on trial for recruiting child soldiers, one of the worst offences in Africa. There are 300,000 child soldiers. It began with Holden Roberto, backed unfortunately by the CIA. He discovered the best way of terrorizing an African village is to have a 12-year-old with an AK-47 blast the headman to pieces. That was the beginning of the child soldiers' recruitment. And of course now in Sierra Leone, the RUF and other organizations found uses predictably for young girls at a very early age as sex slaves. So the ICC is fighting those battles. The Bush administration attitude to the ICC changed, of course, with Darfur, when Colin Powell, on the 10th anniversary of Rwanda, went to the Security Council and said, what is happening there is genocide. He used the G word, which America and Britain hadn't used of Rwanda. Well, that decision enabled America's standing enabled by abstaining the situation in Darfur to be referred to the prosecutor. The prosecutor has investigated and concluded that genocide has in fact happened, and his evidence is very strong. You can read it indeed in the decision to indict Mr. Haroun, who was the head of the Sudanese government and who issue on a Darfur desk, as they called the ministry, and the evidence of the Sudanese government paying the Janjaweed, evidence of them using their air force to bomb the camps to soften up before the Janjaweed attacks, evidence that, as it were, the devils on horseback were followed by the Sudanese army in their Toyota Land Cruisers. It's all there, and it has to be tested. And the way for it to be tested is, of course, for a trial to take place. I think Mr. Haroun, who has immediately he was indicted, he was elevated and made the Minister for Humanitarian Affairs in the Sudanese government. We need pressure on the government to at least yield him up to have the trial. The evidence against Bashir is very much the evidence against Haroun. If Haroun is acquitted, then the case against Bashir will fall away. But they are the kind of issues that require American and deserve American involvement in the ICC. There are also issues on international justice. I don't intend to go into them now. Happy to talk to you later about how to make international trials faster, how to make them more. The Milosevic case took years and years for the prosecution evidence to be heard. There's a great deal of work to be done and lessons to be learnt in making sure that these trials do lift their game, that we have no later than 3 years. There's a tendency for prosecutors to overload their indictments. There's a tendency for judges to be of poor caliber chosen by state nomination, which is always a disaster at the United Nations because states end up choosing people, judges who are not judges at all, but mainly qualified by being the president's cousin. This is the nepotistic problem. There is also the problem of appointing people, judges who are so thrilled to get a UN judge's salary that they have no incentive to finish their trials. We have a number of particular problems. The problem of misbehavior, the problem of disruption. Michael Scharf wrote a terrific book about the Iraqi tribunal in which he had advised that the way to avoid disruption was to force defendants to have a lawyer. They couldn't defend themselves, and so disrupt the court. They had to have a lawyer. Well, that sounded all very fine until the Saddam and co appointed their lawyers, and their lawyers did the disruption, and in the end walked out. So I think the answer has to be a rule that persons indicted for crimes against humanity must take their trial unless they're terminally ill or unable to give instructions. If they refuse to plead, like Charles I and Saddam, or participate in a way that disrupt proceedings, then I think we should move immediately from the adversary system, which does give the defendant the fairest crack of the whip, to the investigative European system, which works very well in Latin America and in many European countries, where a judge does the investigating and then brings his report to open court where it can be challenged. It's a system that doesn't allow any disruption until the final stage and then. Well, the next matter is torture in Guantanamo. How the next administration will no doubt find a way to close Guantanamo, and that many suggestions of trying those against whom there is evidence in a federal court, or at least by way of a military court-martial. As to others against whom there is no evidence fit to be heard, but who are suspected of being dangerous terrorists, there are ways that have been worked out in Britain in relation to a form of house arrest, where individuals in that category, while waiting, can be required to report, can be supervised, can have their computers and so on surveyed, and can be put under a regime which is not one of incarceration, where they can be with their families, but which reduces their danger to society, suspected but incapable of proof, to a minimal level. But what about the record of waterboarding, of the dogs, the Alsatians snapping at the genitals of naked prisoners, and so forth? There is, I think, an interesting point to be made here about the Red Cross. Under international law, the Red Cross gets exclusive rights to visit prisoners of war. And this is very important. And the Red Cross does it very well. But the quid pro quo, which is rather assisted by the fetish that the Red Cross has developed for confidentiality, is that those reports are never published. They're kept in utter secrecy. Now, it's interesting that at Guantanamo, certainly at Abu Ghraib, the Red Cross was aware of what was going on. 5 reports about Abu Ghraib and the brutalities that were going on, all left on desks, not open, not read, or ignored. And it was only when one leaked to the Wall Street Journal that we got the information about what was happening at Abu Ghraib, and then the photographs that became the recruiting posters for al-Qaeda. It seems to me that the United States could do a rather remarkable and dramatic thing. It could announce that it would waive confidentiality in Red Cross reports, maybe 9 months after they'd been made, so that the world, the American people, could see how American prisons were shaping up, if torture or ill treatment was conducted there, what over the 9 months had been done to stop it. I think this would turn Red Cross inspection from being no safeguard at all to prisoners, which it is at the moment, to a real safeguard, and America could show the way in waiving that confidentiality and ensuring that in the future prisoners were properly treated. Had America could take the lead by waiving confidentiality. The next issue is the problem of the death penalty in America. Now, there are 5 countries that contribute to death penalty statistics. 137 countries have abolished the death penalty. But we have China, Iran, Saudi Arabia, Pakistan, and the United States. What great company you're in with the death penalty. And what the problem is, of course, I don't think President Obama could or would abolish the death penalty. It's a state matter. But the problem in international perception comes when the International Court of Justice finds Mexicans who haven't been given consular access, who therefore have had this irregularity and under the Vienna Convention, and order or direct the United States to not to execute them, and the state of Texas or whatever goes ahead with the execution irrespective of the any message from the White House. This is a continuing problem. It means defiance of international law, defiance of a rule based on the Vienna Convention. And it does also lead to problems. There was a problem over the Saddam tribunal in the early days. America, Michael in particular, was doing a lot of work on trying to turn the tribunal into a proper international court, and the British refused to cooperate because they feared, rightly as it turned out, that there would be the death sentence. Of course, the American position, the Bush administration position, was, well, you can't leave Saddam in Iraq alive after the trial, which would be, can't send him to Finland or somewhere where they've got conjugal access and 140 channels of television, most of them showing pornography. That's not a fate. We've got to execute him. And what are you going to put in place? And the British had to think pretty hard. We suggested that they should do to Saddam what they did historically to Napoleon and stick him on St. Helena. And they actually inquired of the people in St. Helena whether they would take Saddam. But they said, no, we're developing a tourist trade and we don't want to take him. So we then suggested, well, what about the Falklands, which would be a very appropriate place for Saddam and Milosevic to commune with the penguins for their life sentence and never be heard from again. But, it is a real issue. What are you going to do with Khalid Sheikh Mohammed? Are you really going to put him in front of a firing squad, a fate that he's been praying for every day of his detention? Or if by some miracle bin Laden is found alive, will he be executed as he wants to be, a martyr, a holy martyr going straight to heaven? Really, surely the death penalty is sort of what the briar patch was to Brer Rabbit for those Islamic terrorists who want it so badly as a pathway to paradise. Right. The United Nations. What can be done about the United Nations? Anthony Lake has, in the Obama campaign, rather joined John McCain's position of wanting to leave the UN and set up an alternative based on the democracies of the world. Well, a good idea for a moment, but how do you define democracy? Is you're going to allow Singapore in, which is an ersatz democracy, that whenever it has an opposition to Lee Kuan Yew or the People's Party, it sues them for libel when they make an election speech, bankrupts them, and then disqualifies them. There are problems with that. There is no alternative to the United Nations as a way forward, but there are areas of human rights that the UN is utterly incapable of protecting or dealing with. These are the right to democracy, which is there in the Universal Declaration, miraculously, the right of free speech. These rights simply have no traction in the UN, for obvious reasons, in the United Nations. And there is, I think, a case for setting up a group. Indeed, H.G. Wells and his committee wanted envisaged that their declaration would be for the parliamentary peoples of the world. So there may well be a case for setting up an organization of democratic states to deal with the problems. I mean, Fiji, take Fiji. Fiji is 750,000 people. The army have once again thrown out the parliament and installed a military dictatorship. America, Australia, and New Zealand could, at the flick of a switch, just simply by denying landing rights to the Fiji airline to Los Angeles, and it's probably justified for safety reasons. It's the only airline that still flies planes with ashtrays in the seats. But you don't take this action, and the instability in the Pacific that the dictatorship, the army overthrow of democracy in Fiji is causing is very worrying to those of us who know what is happening there. And yet, Fiji peacekeepers, the Fiji army is accepted as the United Nations' favorite peacekeepers. They go off and keep the peace and then come back and throw out the government and set up death squads and torture squads. This is simply unacceptable. And Zimbabwe is another example. Commonwealth Secretariat utterly incapable of doing anything about the decline and devastation in Zimbabwe. We do need an organization, I think, limited to democracy and free speech. And there is also the problem of UN peacekeepers. I won't spend any time on it. It is a problem of the ragtag and bobtail armies of the world turning up without kit, expecting pay. Look at the Congo, 17,000 UN peacekeepers, but what a trying to keep peace where there's no peace to keep, but they're mainly Indian and Bangladeshi divisions. Again, serious thought has to be given where, as in the Congo this week, there is the threat of annihilation of tens of thousands of people. There is, I mentioned the new idea of selecting judges on merit. I'm in fact, I'm a member of the Internal Justice Council of the United Nations, which was set up at the insistence of UN staff who found that they give up their employment law rights when they joined the UN. They had no protection at all when they blew the whistle on corruption, when they were unfairly dismissed or bullied, when they were the victims of sexual harassment. Kofi Annan got his mate rude lubbers, a very important position, and he was sexually harassed a number of women who couldn't, in the UN system, complain. So finally, the management and the General Assembly agreed to set up 5 full-time judges to police the United Nations and deal with all those cases, and 7 appeal judges. But more importantly, they agreed to have selection of judges by merit. Now, selection on merit is something that is completely alien to the United Nations because all these positions are selected either by state nominations or by the Secretary General's favourite friends. And a committee, the Council, advertised widely in The Economist, the Wall Street Journal. We got 250 judges who'd served for 15 years on the high courts of their countries. We had them 40 of them in The Hague. We set them an examination, a competitive examination. 3 hours they had to spend answering and writing a judgment on an exam paper. And some of them, you realize, were out of practice. Obviously, all their judgments are written by their associates. But and the result, our report is about to go to the General Assembly, but there are 2 Americans that we have, American judges we've nominated. A merit selection we maybe see, this has come about because of the pressure from the UN staff, but it is a reform, an extraordinary reform at the bottom. But nonetheless, it may enable, it will certainly end the hypocrisy of the United Nations not practicing what it preaches. Well, finally, let me say that the promise of the Rump Parliament all the way back to setting up the court for trying Charles I has taken one extraordinary development, and that was 2 weeks ago, on the anniversary, the 10th anniversary of the indictment of General Pinochet, or the issue of the extradition warrant for him. Balthazar Garzón, the courageous Spanish magistrate who took that extraordinary step, has taken another extraordinary step. He's opened an investigation into the death squads set up by General Franco during the Civil War to kill secretly so many thousands of Republicans and those who were seen as enemies of Franco. And so, arguing that, drawing his authority from decisions in Latin America that death squad disappearances, kidnappings remain crimes against humanity, giving jurisdiction to investigate them until the bodies are located, arguing that there can be no posthumous impunity for the organizers of torture and mass murder. So that chimes in with a recent protest by China against the way Japan was whitewashing its past in its school textbooks and was not facing up to the human rights violations in Manchuria and the rape of Nanking. So I think we're seeing this new aspect. Well, it's not new, of course. It was there in the Universal Declaration. The Universal Declaration does call upon the nations of the world to teach the values of human rights and to own up to their own failings and to teach honestly. And so we're seeing finally a demand that there should be an owning up, a saying sorry, as the Australian government has said to, and other governments have said, that there should be an education in human rights and the production of textbooks that are honest about past human rights violations. Well, they're just some of the ways in which human rights may be better protected in the future, certainly if the United States is prepared for active re-engagement in the struggle for global justice, and at a time when people around the world today are actually waving American flags and not burning them. I think there is a real possibility of recognizing the spirit of the of the levelers, the spirit, certainly, of Roosevelt's four freedoms of the Atlantic Charter, and delivering on Eleanor Roosevelt's hope that the Universal Declaration would become the Magna Carta of mankind. Of course, the world is very different now. The problems are more complicated, and there will be many more immediate problems to be dealt with as a result of the recession. Short-term problems, but in the long term, it is the contribution that the new administration can make to the global struggle for justice that may make this week's election historic, not only as a watershed in American history, but in the history of the world. Thank you very much.
Geoffrey, will you take 15 minutes?
Surely.
Anybody?
Yeah.
We have a microphone that you need to speak into because this is being webcast around the world. So please wait for the microphone and then ask your question and keep it short.
Mr. Robertson, thank you very much for your talk. You really covered a lot of ground. Okay. Okay. My question is that under English law, I believe there's a right to do anything that's not prohibited by law, and that seems like an important basis for human rights. And if there is such a right, can you tell us the origin of it? It's important for Americans because you don't hear about that right here, and if it's from the common law, it should be also an American right because we have the common law.
Yeah, it is a principle that is much advocated, much argued about before the Human Rights Act. It was actually enunciated most recently in a case where a individual who had in fact been innocent but had had his telephone tapped, and he went to court based on all the old John Wilkes cases about invasion of privacy and so on, and claimed that his rights to privacy of home and family and so forth had been invaded by this telephone tap decision, which had been made entirely by the executive. There was no law. And the judge turned round and said, we have this great principle of liberty, that if there's no law against it, you can do it. So there's nothing to stop the government doing it because there's no law against it. And that was in 1979, and that the enunciation of that principle persuaded many of us that it was important to have a law against it, and we finally, the Blair government, in fact, did introduce the European Convention of Human Rights. It repatriated. The European Convention had been based on the Universal Declaration, and it had been signed up to in 1950 as a way, European countries signed up to it to persuade those countries that were minded to think of going communist that, in fact, they should have these basic human rights. So the Universal Declaration now has become enforceable in Britain because in 1998, partly as a result of that case, we introduced the Human Rights Act, which does give a protection for the privacy of home and family, and introduced laws as well to regulate telephone tapping. So it's an important principle in one sense, in that it can be asserted against attempts to develop new crimes or to spin out of old crimes an application to new circumstances, and it still remains important there. But beware of it to this extent, that it can be a warrant, if you like, for executive government to do what hasn't been thought about before, and it was used, unfortunately, in that case.
Sir, my question was, where did the right come from?
Well, I can give you the case and look up the origin of it. It's been asserted by English judges over the years that if there is no, and it's not enshrined in a statute, and it's not, in Magna Carta, I suppose most things go back to no one will we deny or delay justice or right, in the sense that there should be no imprisonment without law is all part of that theory. But you'll find it enunciated in various cases over the years. In the last cases I say that I know of, it was enunciated in support of executive overreaching. Yeah.
Thank you very much for an absolutely engaging presentation. I'm afraid that you have certainly whet our appetite, and I'm wondering whether you did actually cover a lot of the issues related to the future of human rights. Globalization is here to stay with us, and I'm wondering whether you might be willing to sort of forecast how human rights enforcement might be used in a business or corporate setting, especially with corporations doing businesses in certain countries where there aren't that much of a strong emphasis on human rights, etc.
I'm glad you asked that question, if only because I'd left it out because I was running out of time. Yes, there is an important dimension, terribly important issue, and very complicated issue actually, of what to do about the transnational corporation. We live in a world where transnational corporations are enormously powerful. In fact, of the 100 most powerful, wealthiest entities in the world, 51 are transnational corporations, 49 are states. Texaco, as you said, has a wealth 4 times that of Ecuador. Yeah, you can go on with showing the power of corporations. You can also go on with showing the dismal record of corporations, particularly those in the extractive industries, in mining, and in the garment industries, in the latter case using child labour, sweated labour, contrary to ILO conventions, in the extractive industries cases of using, usually by way of complicity with the regime, appointing paramilitary guards of oil pipelines. This was the Unocal case, the Chevron oil case, and so forth. And so what to be done about an international law that only binds states, and in some case international criminal law binding individuals? But where do you put the corporation? In one sense, America has the Alien Tort Claims Act, which is a marvelous act dating, I think, from 1789 or something, which enables, although the Supreme Court limited it a bit in the Sousa case, it's still available and still can be used against transnational corporations that commit outrages, get themselves involved in killings, in death squads, in torture, or in slavery. So there is, and this is unique to America. It is not replicated in other countries. You have this extraordinary act, which is used, for example, there was the terrible example of Yahoo that gave away the details of its subscriber who was an anti-democracy activist and is now serving 10 years in a Chinese jail. So there is, now what the first UN committee to look at this came up with, the first thing that was done was by Kofi Annan, who set up the Global Compact, which was a voluntary exercise where corporations could pledge without any downside their acceptance of human rights principles in their business. Now, this was ineffective, except in a few cases because it required sometimes corporations in their annual report did actually say that they were signed up to the Global Compact, and it was if you showed that they if NGOs could show that they had breached the principles of the Global Compact, then there was a bit of bad publicity for them. But that was as far as it went. Then this committee came up with the idea of norms, binding norms that could be enforced. And that, of course, was anathema to America, Britain, quite a number of other countries where transnational corporations are headquartered, were very much opposed to that. Amnesty International and Human Rights Watch were in favour. But this has developed to the stage where a gentleman called John Ruggie has been appointed as a special rapporteur on the way forward of how to bring transnational corporations into the human rights enforcement area. He issued his report on October the 10th. It's a very long report and in some respects was disappointing, but it was a work in progress because his initial suggestion was that other nations, to preserve the right of the state to deal with its own corporations, that other nations should adopt a kind of ATCA, Alien Tort Claims Act, national law. Now, there are problems with that. He's promising a new report next year, so it is an ongoing concern to see what will eventually come. And it's one, again, I think that the new administration will be called upon to have an important input into the final solution of how to bring transnational corporations within the scope of international law enforcement.
One last question?
Yeah.
Yes. If Barack Obama walked in the footsteps of Richard the Lionhearted, that like he did in 1194 and called off the crusade and attempted to establish peace and justice in his own country, do you think that the new situation would create more respect for human rights overall in the world or less?
What do you mean? That if Barack Obama came and started to sort out human rights in this country, would he?
Yes, so sorted out human rights in this country and shifted less attention toward crusading in other countries.
Well, yes, the whole concept of the crusade has been enormously damaging, I think, to American prestige around the world. And it is a great pity that the language sometimes used by what will in 3 months' time be the previous administration has given the impression that this is a kind of Christian crusade against the Muslims and others. But in fact, it is important, I think, one can see this in Obama's language, to deal with terrorist atrocities as crimes. They are crimes against humanity. And in developing models for dealing with terrorism, it is important to deal with them as crimes rather than as some kind of war. It's not a war as we know it conventionally, and it's dangerous to apply the kind of shortcuts that you can get away with, perhaps in war, to dealings with other countries and with the citizens of other countries. That has been, I think, the problem of Guantanamo Bay. I do detect in Obama's language, when he talks of terrorism, a sense that he is prepared to deal with it as a crime against humanity, and as a crime by those who, as I say, want to kill Americans and anyone else who gets in the way. But the importance, I think, of dealing with it as a crime and not as some kind of crusade, is to assure the world, really to assure the sympathizers and the communities from which terrorists come that they are not the victims of discrimination, they are not the victims of oppression. And that is why I think those communities are today already less sympathetic to those members who engage in terrorist activities. And that always, in theory of dealing with terrorism, you can see it in Thompson, the general who was in charge of dealing with terrorism in Malaysia in the 50s, wrote very powerfully of the need to divorce the communities from which the terrorists potentially come from terrorist actions. And I think those communities are seeing today an example of the possibilities of human rights as seen, as actually produced in America. And so I do think that that is going to provide a moment, I hope it will last years, in which America can be a leader of the free world, not a crusader of the free world. I mean, just take parliamentary democracy, this absurd idea that you can invade Iraq and then set up a parliament and everything's going to be hunky-dory. I mean, it's taken us 360 years to get the democracy we've got, and we still have campaign financing, you know.
On that insightful note, thank you very much. We will not let you leave us empty-handed. This is just something to remember us by. It's a globe, and it dedicates this to your wonderful presentation. And also, because the nice weather we're having is bound not to last, we, of course, have one of our famous Cox Center fleeces, which will keep you warm tomorrow while you're still here. And again, one last time, we're going to have a reception for a half hour afterwards. You'll get a chance to ask Geoffrey Robertson the individual questions you have and meet him. But please, once again, join me in thanking him.